Good afternoon. Thank you for joining us. My name is Patricia, and I work with the City of Mountain View's Rent Stabilization Division. And this afternoon, we're giving a presentation on eviction protections that is focused toward property owners. So that is why we're here today. Also joining me is Ankie Van Dursen. Ankie, would you like to say hi?
Good afternoon, everyone. Welcome, and thanks for taking time to be with us today here on the webinar.
Thank you, Ankie. We're going to go ahead and get started. So the first thing that we want to mention to you is that we are not able to offer, as city staff, legal advice, but we can offer facts, information, best practices, and an overview of the CSFRA, the MHRSO, and any other applicable state laws. We will have multiple times throughout the afternoon for you to ask questions, and we will coach you through that at each opportunity. You'll basically use the Q&A function that you see down on your Zoom bar, and you can ask questions through there, or you can raise your hand, and we will unmute you and allow you to speak. So the first thing we're going to cover today is a very high-level overview of the CSFRA and the MHRSO. So that's the Community Stabilization and Fair Rent Act, and that's mostly applicable to almost every apartment complex in the city that was built before the law went into effect in 2016, which is the majority of our apartments and units in the city, and the Mobile Home Rent Stabilization Ordinance, which is an ordinance that protects mobile homes in the city, about 1,130 of them. And what does it do? Well, the whole point of these two laws is to stabilize the community by reducing housing turnover in certain rental units and mobile homes. And it does this in three ways. The first one is by stabilizing rents, so no unexpected rent increases. The second one is by providing eviction protections. And the third is to ensure a fair rate of return for property owners on their property. Most apartment buildings, like I mentioned before, are covered by the CSFRA. And the law went into effect on December 23rd, 2016. So that's why you see this date here. There's two types of coverage: fully covered units, where both rent stabilization and eviction protections apply. Those units are generally not a government or subsidized rental unit and were built before 1995. And then there are partially covered units. Those units have eviction protections only, and they are built between 1995 and when our law went into effect, and again, are not a government or subsidized rental unit. Mobile homes are covered by the Mobile Home Rent Stabilization Ordinance. So again, there's two laws in Mountain View, the CSFRA and the MHRSO. The MHRSO protects mobile home owners and their space rent. What does that mean? It's for people who own a mobile home and rent a mobile home space, including the communal facilities and housing services from a mobile home park owner. It also protects mobile home renters, and those are people who rent their actual mobile home in a mobile home park, and the rent includes communal facilities and housing services from a mobile home landlord. So there's two slight differences there. One person is renting the mobile home space, and the other person is renting the actual mobile home. So as we just went over that quick overview, we have our first opportunity for questions. Does anyone have any questions about what we just discussed? So you can raise your hand or use the Q&A function, or press *9 if you're calling in on a phone. Okay, and at this time, I don't see anyone with any questions, so we're going to move right along. So first up are some basic information about eviction protections. And Anki, let me know if at any time you want to jump in and present any of the slides. So mobile home owners, we're going to cover that first. Mobile home owners, not mobile home renters, but mobile home owners, are covered by state law, by the Mobile Home Residency Law, Section 798 256, which provides eviction protections for mobile home owners. There are limited causes for eviction, and those include the failure to pay rent, the violation of park rules and regulations, substantial annoyance, non-compliance with state or local laws and regulations related to mobile homes, the condemnation or closure of a park, or the change of use of the entire park or parts of a park. For mobile home renters and CSFRA covered units, just cause reasons are in effect. So these are just cause reasons for termination. There are 9 of them. You can think of them as tenant caused and landlord caused. The first batch, tenant caused, include issues like failure to pay rent, the breach of lease, nuisance, criminal activity, or failure to give access. For the ones that you see here that have asterisks, they require a notice to cease before a termination notice can be given. And then over on this other side, we have landlord-related causes. And these include repairs or temporary vacancies to the unit, owner move-in, withdrawal from rental market, and the demolition of the unit from the market. And in those cases, you'll see those 2 asterisks there. Relocation assistance and the first right of return rules apply to those units. So those are specific laws and regulations that are in effect for landlord-caused terminations, and we'll discuss some of that a little bit later. So next up, what are the noticing requirements related to terminations? This is important stuff here. Noticing requirements, like I mentioned on that last slide, if a tenant is causing an issue, you're required to give a notice to cease, except for that 3-day notice to pay rent or quit, before the termination notice is given. And this allows the tenant an opportunity to address the violation before the termination notice is given. You need to give this notice to the tenant and provide our division telephone number on the notice, which is 650-903-6136. There are also, for notices of termination, termination timelines that are associated with them. We have the 3-day notice to pay rent or quit. There's a 30-day notice, a 60-day notice, a 120-day notice, or a year-long notice. These notices must detail the specific reason for a termination, notify tenants of the potential right to relocation assistance, and you need to provide a copy of these notices to our division, to the Rental Housing Committee, within 3 days. And you can do that in a couple ways. You can email it to us, you can mail it to us, or you can hand deliver it. Or what we prefer is that you use our portal at mvrent.mountainview.gov, which you should all have registered your units, so you should be well versed in how to use the portal. And you can upload your notice of termination right into that portal. If you need any assistance, we can help you upload that into the portal. There's also a notice of intent to withdraw rental units from the market. This also requires tenant relocation assistance be involved in this portion of the noticing. Anki, do you have anything that you'd like to add to the noticing requirements?
No, other than if you have very specific questions, feel free to call us and we can help you determine the correct noticing for your specific situation.
And you can call us at this phone number here, 650-903-6136. So notice to cease. What is a notice to cease? You're required to give a notice to cease prior to giving a notice of termination in the following cases: a breach of lease, nuisance, complaint of criminal activity, and failure to give access to the unit. A notice to cease is a written warning that must include any information necessary to determine the date, time, place, and other circumstances concerning the reason of the notice, a reasonable period and sufficient details to allow for compliance with the notice, information on the tenant's rights to request reasonable accommodations, and our division's contact information. which again is 650-903-6136. So this is that notice to cease that you have to give before you give a termination notice for these reasons here. If you give the notice to cease and they don't clear the violation in a reasonable amount of time, then you can provide a termination notice. So notices of termination, we have kind of 3 different buckets. The notice to pay rent or quit, which is a 3-day notice if a tenant has failed to pay rent as required. That does not require a notice to cease. A termination notice, 30-day notice if the tenant has rented for less than a year, and 60-day notice if the tenant has rented for more than a year. And then with withdrawal from market or demolition of a unit, those termination notices require more time. So you have to give a 120-day notice if it's a withdrawal of the unit from the rental market, and a 1-year notice if it's a withdrawal from of the unit from the rental market and the tenant is a senior citizen or is disabled. So if you're thinking of issuing a termination notice, there's a few things that you're going to want to do. One is contact our office when you're considering terminating a tenancy. We can help with making sure that some of the things under the law are followed correctly and that you have the right information that you're giving to tenants, including our phone number in those notices. We can provide information on those CSFRA and MHRSO requirements, and in cases where there's maybe a conflict or a concern or one of those tenant-caused notices, then we can connect you with resources like the Mountain View Mediation Program that can resolve the issue without having to go to court. And we are, Anki, did you have anything you wanted to add in here? And we are at our next time for questions, and I see we have one, so I'm going to go ahead and allow you, Daniel Hernandez, to talk. And you can go ahead and unmute yourself now.
Thank you. Question is, what is sufficient time for the cease notice to cure itself? Like, I mean, we're talking 3 days, 5 days. What would be ideal?
Yes, and that is a good question. And it also depends on the violation or the type of termination notice that you are planning to give. If, for instance, there is a hoarding situation, you need to give the tenant sufficient time to clean up all the extra boxes or stuff that are in fire exits or access points in the house. If it's a simple thing, then the timing could be shorter. So in the end, yeah.
I was going to say, so ideally in a hoarding situation, let's say, what would be the sufficient timeline? Are we talking about a week, 2 weeks?
Again, that depends on a case-by-case basis. And the law, the CSFRA, does not stipulate what reasonable means. So in the end, the reasonableness factor will be decided by a judge if it comes to that.
Okay. That was the only question I had.
Great, thank you, Daniel. I'm going to go ahead and turn off your ability to talk. And then we also have a question here. Yes, we will be sending the video recording. It'll be on YouTube, and we'll send the slides out. We'll send a follow-up email to everyone tomorrow, or, oh gosh, is today already Thursday? Tomorrow or Monday. And it will have the link to the YouTube, and it will have any additional slides or information that we can provide as well. Okay, are there any other questions before we move on? Looks like no, so we can go ahead and continue. So the next step is, what is not a reason for eviction? So we covered what is a reason for eviction, what is allowed under the CSFRA and the MHRSO, and now we're going to cover what is not allowed or not a reason for eviction. So there's some different reasons here. The first is a lack of cause or no cause. No cause evictions are no longer allowed. Terminations must include one of the 9 just causes. So at the end of a lease, a tenant is not required to sign a new lease. If they so choose, there are no changes in the lease terms. The lease terms from the last lease simply roll over. And they also automatically roll over to a month-to-month tenancy for the tenant. So the tenant can provide 30-day notice to vacate, but the property owner cannot provide a 30-day notice to vacate. So again, it's month-to-month for the tenant, but not month-to-month for the landlord. And again, a tenant can give a 30-day notice. So that one can be a little confusing. Just a brief overview of that again. The end of a lease is not a reason for eviction. Simply, the lease turns over to a month-to-month lease for the tenant. The lease terms remain the same, and you can give, if eligible, the annual general adjustment of rent just by noticing the rent increase. Another reason for that is not covered, or that is not a reason for eviction, excuse me, is the sale or transfer of a rental property. So noticing of new ownership information is required to be given to a tenant, and the tenants do not leave. There's no change in their tenancy. Rent increases cannot be given unless followed under the law. So the whole 12-month, can't have a rent increase within 12 months of the last rent increase is still applicable. The annual general adjustment is still applicable. And also, banked rent increases go away. If the previous owner had not given rent increases, those banked rent increases are no longer eligible to be given under the new ownership. Also, another reason that is not a reason for eviction is the unreasonable denial of an additional tenant. This includes a one-for-one replacement of a roommate or the addition of a family member. So reasons that are not reasons for eviction is the lack of cause, no cause terminations, the end of a lease, the sale or transfer of a rental property, and the unreasonable denial of an additional tenant. Constructive evictions are illegal. Here are some examples of a constructive eviction: changing the locks, cutting off utilities, harassing occupants, preventing occupants from entering the unit, and not addressing habitability issues or not maintaining the property. So these are illegal. These are illegal under state law. You cannot do these things. What is Anki, did you have anything you wanted to add to this section before we move on?
Maybe if there are any questions up till now. It's quite detailed. No? Okay. Oh, Danielle has another question.
Hi,
Yes.
Daniel.
Hello. The question regarding the and I forgot what it was really about the
Maybe go back one slide.
yeah, it's just about the changing of tenancies or occupancy basically. Would that apply to over occupancy of a unit? So let's say a 1-bedroom unit and there's like, let's say 6 or 7 people or 10 living in there. Would that still not be a reason for eviction?
That could be a violation of your lease if the lease states exactly how many people are allowed to live in that apartment.
Okay. So then the question becomes, as far as a notice of cease, violating the terms of the lease for having, more people than it's on the.
So you need to first send a notice to cease. It seems you have more occupants in your apartment than is allowed under the lease. This is a lease violation. Please correct that before I give a termination notice.
And then what would be the timeline, I guess, for that one as well? I mean,
yeah, And again, you're getting the same answer from me. It's like the reasonableness. But having people move out, you have to determine what is a reasonable amount of time for that, maybe before the next monthly payment of the rent. I mean, you have to just argument why you choose the timeline that you choose.
Okay. That was it.
Mhm.
Good question. Thank you, Daniel. And Carol, I'm going to allow you to talk. Go ahead and unmute yourself.
Hi. So my lease with the tenant is ending. It's a 3 months lease, and I do not want to renew the lease or change it to month with the tenant.
So
Yes.
again, go ahead, Anki.
Oh, I'm sorry.
No,
So
no.
I first want to check if you're in a CSFRA covered rental unit.
What does that mean? How do I know that?
So you can actually, this might be a good question for us to take offline outside of this
In general,
workshop,
yeah,
but we can so that we can answer your questions. I don't want to have your private information displayed to everyone here, as you know, if you're the owner of the property. So I can follow up with you tomorrow, Carol, and we can get some detailed information out to you to make sure that we're giving you the right information. If you if you own a covered rental unit, like we were saying at the beginning of the presentation, they're typically, most apartments in the city are covered by our rent stabilization and eviction protection law, the CSFRA. It's in general, properties that have 3 or more rental units that were built before 1995 that have full protection, so rent stabilization and eviction protection. And if it was built between 1995 and when the law went into effect in 2016, then it has eviction protections. And if you are covered, then the end of a lease, the end of your 3-month lease would not be a reason for eviction. So that tenant would be allowed to stay in the unit. But I want to make sure I'm giving you the right information. So I'll follow up with you. I have your email from the registration for the workshop. So I will pull that and I'll email you this afternoon so that we can follow up with you.
Yeah, and then to add, in general, a condo or a duplex or a single family home, those are exempt from these rent stabilization rules.
It is a condo, it's a townhouse.
Yeah. So I
that
can already tell you that the CSFRA is not applicable to you.
But then the state law, AB 1482 is, or may be. And so, Carol, I'll still follow up with you and I'll send you the link to the information for state law AB 1482 because that has specific requirements on how you can remove a tenancy as well.
Okay. Thank you.
Thank you for your question. Are there any other questions?
Are there any other people that do not know whether their property is covered by the CSFRA or not? Feel free to reach out to us at any time if you have questions.
Okay, so we're going to move on to the eviction process in California, and I'm going to let Anki take these slides.
Yes. So the eviction process in California applies to the city of Mountain View as well. So the CSFRA does not give follow-up procedures once you have given a termination notice and the tenants are not moving out according to that termination notice. So if the tenant is not moving out after that termination notice, you have to go to the courts and you have to file a summons and complaint. And that is called an unlawful detainer. That means the tenant is unlawfully detained possession of the house. So once you file that summons and complaint, a copy goes to the tenant. and the tenant has 5 days to provide an answer. If a tenant does not file an official answer to your UD filing, you will be getting a default judgment against the tenant. And with that default judgment, you can go to the sheriff's office and they will put a notice on the door of the tenant that they have to leave in 5 days. If the tenant does provide an answer on your formal filing, this case goes to trial within 20 days. And if a tenant loses, you can go with that judgment again to the sheriff, who will put a notice on the tenant's door. If a tenant wins, the tenant gets to stay. And this is kind of a short process overall. As you can see, once you file your summons and complaint, the tenant has to answer within 5 days. If an answer is received, then it will be set on the calendar within 20 days. So this is the shortest process you can imagine for a court procedures. On the other hand, it's very technical. If in your summons and complaint, you say the tenant hasn't paid the rent and the amount that you state is wrong, that is a defense for the tenant to fight you on that. So make sure that all the details in that summons are exactly correct. Also, I also wanted to mention, you need to file termination notices to the city, but you also need to file a UD with the city. If you don't, a tenant can use that to their defense as well. Any questions about this wonderful court process?
And again, you can file those notices with us through a variety of means, but the easiest one is through mvrent.mountainview.gov, our portal that you use to register your property. So are there any questions about the actual court process here? Nope, it looks like we have one. We have a couple now trickling in. Go ahead and pull that slide back up. Melissa, I'm going to allow you to talk. You can go ahead and unmute yourself.
Hi there. I was wondering, do we have to submit the 3-day notice and to pay rent or quit, or and the unlawful detainer?
Yes.
If it gets that far? So
Yeah,
both of
that's
those
correct.
documents?
Yeah.
Gotcha. Okay.
Any other questions, Melissa?
Oh, no, thank you so much.
All right, Rob, I'm going to allow you to talk. You can go ahead and unmute yourself.
Yeah, can you hear me?
Mhm.
Okay, yeah, I'm going through a UD right now, the court date late March. And one of the tenant's defenses is that the payments he made was not counted on his ledger, even though 2 of them bounced back. And I know the submission was given a receipt by email, return receipt, but it wasn't reviewed, just an acknowledgement. So are you saying that we also need to submit like the court appearance document as well? Or what are you saying? What else do we need to submit to the city?
Just the termination notice and the UD filing. When you file for UD, you submit that to the city.
When you file for, you mean the lawyer's paperwork?
What you file with the court, the UD filing, the summons.
Oh, the summons. Okay.
Mm-hmm.
Okay. It's good to know.
Not a fun process to go through. I'm sorry.
Oh, yeah. No, that's fine.
Mm-hmm.
Do you have any other questions, Rob?
No, no.
Great. All right, and we've got some questions here. Do you have to file with the city even if your unit condo is not covered? No, if your unit is not covered by the CSFRA or the MHRSO, these rules are not applicable to you. Yes, you do need to file the pay or quit with us through mvrent.mountainview.gov, and it's within 3 days. And another question, same answer. Do we need to submit 3-day notices to the portal whenever a tenant doesn't pay rent and has been served a 3-day notice? Yes, you do. That is required. Again, mvrent.mountainview.gov. And you can always ask us, give us a call if you need help with that, or send us an email at mvrent@mountainview.gov. So slight differences there in the how you're accessing things. mvrent.mountainview.gov is our portal. mvrent@mountainview.gov is our email address. All right. So we are almost done actually with our presentation today, and we do want to go over some key takeaways. So tenants can only be, like we discussed, evicted for 9 just cause reasons. No cause evictions are not allowed, including the end of a lease. The end of a lease is not an allowed cause for eviction. Landlords must notify tenants in writing of the reason for eviction. And also remember that you can contact us as soon as possible if you give a termination notice so that we can help you navigate the process. We also have a housing help center. It's happening today. You're part of it right now for landlords, and it happens on the first and third Thursday of the month from 1 to 3 p.m. You can join us for this by going to our office at 298 Escuela Avenue, or by joining at mountainview.gov/housing help clinics. It is available virtually and in person. And then we do routinely have workshops like this one that coincide with the Housing Help Center, and we give them virtually as well. And that is well, we do have some resources we can go over. So I'm going to go over those resources before we have another chance to talk. I mentioned this earlier, but Mountain View has a wonderful program called the Mountain View Mediation Program, which provides free mediation services to the community. It is confidential and has a very high success rate when both parties agree to mediate. If you'd like to learn more about the mediation program, you can go ahead and call 650-960-0495 or email mediate4mv@housing.org. Again, this is a fantastic program and we highly encourage you to use it. It is free and much faster than going through the court system. There are also additional legal resources for property owners in the county. The first is the Santa Clara County Bar Association's lawyer referral service. So if you need assistance, this is a great place to start. There's also the Superior Court's Self-Help Center. Both of these resources provide free information and can get you connected with different additional resources available to you. And then finally, here's our information one more time. You'll see it on the screen. You can contact us by phone, email, visit our website, which has a wealth of information on it, or you can come visit us at our office live and in person. We also have these housing help centers that I mentioned earlier for landlords. We also have them for tenants. So if you have tenants that are in need of assistance, you can send them on over to our housing help center. It is for tenants as well on the first and third Thursday of the month from 6 to 8 p.m. So we have the landlord one from 1 to 3, and on the same Thursday, the tenant one from 6 to 8. And we do often have property owners who give this information out to their tenants. And if you need information about it, we are more than happy to give that to you. One thing that we do as a city is provide information to tenants when we receive a termination notice. They get information about resources that are available to them in the community. And property owners have been known to give that information out to their tenants as well. So if you would like a copy of what we give, we're more than happy to provide that. just always feel free to reach out to us. Kind of the earlier the better in these processes, and we can connect you with support more quickly. And that's it for our portion of the presentation. Are there any additional questions out there, or does anyone have anything that we can help them with today? Well, I'm going to give just a few more seconds for anyone to think of some questions or any kind of support that they might need. And it looks like we have answered everyone's questions about terminations this afternoon, Anki. Thank you everyone for joining us. We will be sure to send out a follow-up email with some additional information, including the recording and the PowerPoint slides as a PDF for your resources. And again, feel free to contact us. You can give us a call at 650-903-6136 or email us at mvrent@mountainview.gov with any questions, and we're happy to help. Thank you again for joining us, and we will see you in the future. Have a great afternoon.